The other key question that we need to ask in relation to administrative law relates to the question of boundaries of administrative law. We earlier said that administrative law touches on various aspects of society, such as social security, veterans' entitlements, business regulation, immigration, taxation, and welfare rights. And if you notice, the common thread among these matters is that the rights of persons and government and corporations, for example, are often affected by government decisions and action, and therefore there is a right on the part of persons and corporations whose rights have been affected to actually seek a review of such government decision-making and action. So if you look at it from the viewpoint of the parties that are usually involved in administrative law, you can see that it involves rights and it involves persons and corporations on the one hand, and the executive government on the other. And we can look at it visually from this illustration here, where you have the executive government on the one hand and persons and corporations on the other, and it is administrative law which provides the interface by which persons and corporations can actually seek a review and ask for an accountability on the part of executive government for its decisions and actions. We can contrast administrative law by looking at constitutional law, for example, and we see that the parties involved in constitutional law would be typically the three branches of government, who would then often have conflicts in the way that they exercise their powers. Be mindful that under the notion of separation of powers, we seek to avoid a situation where a single branch of government is able to wield the power to pass a law, execute the law, and interpret the law, what the law might be, because then that gives you an instance of autocracy or despotism. So being mindful of the separation of powers tells us that each branch of government must always attempt to be a check and a balance on the other branch of government. Although in the case of Australia, we do have a limited notion of separation of powers, because the members of the cabinet who form the executive government are actually part of the legislature. So there is therefore a very strong opportunity for the executive government to be able to push its agenda in the legislature, and mainly because the executive government, meaning the prime minister and his cabinet, typically belong to the political party that controls the legislature, or mainly controls the House of Representatives. We can also look at constitutional law as involving a conflict in the exercise of powers by the legislature and the judiciary. And it is then the task of the judiciary, for example, to make sure that the legislature exercises its powers according to the limits that are imposed by the Constitution. Constitutional law can also be looked at from the viewpoint of a conflict in the exercise of powers between the Commonwealth or federal government and the state governments. Now let's look at civil law. And you will notice that as far as civil is concerned, the parties involved are two persons. So party A files suit against party B. It can also be about one person against a corporation, or a corporation against another corporation. Of course, that's a very simplified way of trying to look at the boundaries of administrative law by looking at the parties involved, and trying to contrast administrative law versus other fields of law by looking at the parties involved. If you look at consumer law, the parties involved would typically be the consumer versus a corporation or business. And criminal law would usually involve the Crown versus the accused.